Hey, it's Paris. You know, I love sparkly things, right? Like stars. Duh. And thanks to Hilton and AutoCamp, I just slept under them. Picture me, serving looks by the fire outside my luxurious Airstream, making s'mores with the kids, while a national park is our backdrop. The great outdoors meets Hilton hospitality. That's hot. Explore all the new ways to stay at Hilton.com. Hilton for the stay.
Hello, I'm Amy Westervelt, and this is a special crossover episode of Drilled and Damages. Today, I am joined by Sankar, Senior Vice President of EarthJustice, and Kirti Datla, Director of Strategic Legal Advocacy for EarthJustice, to talk a little bit more about what exactly the West Virginia versus EPA decision meant, and to look ahead at some of the big cases for climate folks to be watching in the next Supreme Court session coming up this fall. There's a lot to get into here, from the continued attempt to dismantle the quote-unquote administrative state to the way that the Clean Water Act is being targeted in a case coming up next session, to how litigation remains a very important tool even with the Supreme Court on fire. We're going to get into all of that and more coming up after this quick break.
How does PwC take your company to the leading edge? They bring the sharpest minds in tech to your team, so you can bring the ideas that will transform your business. They're passionate about your industry, so you can walk into any room with every advantage. And they're with you every step of the way, so you can know you're headed in the right direction. PwC builds for what's next, so you can get there now. Get started at pwc.com/us/leading edge.
The Abercrombie Kids Summer Sale is in full swing, with up to 50% off select styles for the season. Summer plans, vacation, and camp days are all covered, with new dresses, shorts, tees, and swim. Abercrombie Kids has the summer staples they need and the looks that they want to wear. Shop in-store, online, or in the app. Offer applies to select styles as indicated. Discount applied at checkout online.
My name is Sam Sankar. I'm the Senior Vice President of Programs at EarthJustice, which means I lead our lobbying and litigation efforts.
I'm Kirti Datla, and I'm the Director of Strategic Legal Advocacy at EarthJustice, which in a nutshell means I kind of keep track of the goings-on in the federal courts, especially the Supreme Court, on issues that kind of crop up across all of our cases.
Okay, so I know that it's been a while since the West Virginia versus EPA decision came down. With a couple months, past it, what do you think the implications of that decision are or will be?
Yeah, totally. So, I think your listeners are already pretty well versed in this case, but just as a reminder, the case is ostensibly about this Obama-era regulation called the Clean Power Plan that addressed emissions from fossil fuel-fired power plants. But that regulation was sort of a zombie regulation that had, because of the Supreme Court issuing a stay, never got into effect. And that was sort of kind of practically dead for all purposes. And the Supreme Court took a case that was about whether or not that zombie regulation was valid, largely to address something called the Major Questions Doctrine, which had sort of been cobbled together out of a couple sentences here and there in the Supreme Court's past cases by folks like West Virginia and the group of states that it was leading in this case, and the industry groups that were on their side. And as they put it to the court, the idea is that if a federal agency is going to address something that has big economic and political consequences, it needs to be able to identify something really clear in the statute that gives it the authority to do basically exactly what it tried to do. And, it's sort of obvious just from describing the doctrine that they pitched to the court that it is inherently deregulatory. It only applies when the government wants to do something. And the kind of test that it asks agencies to overcome is one that will be hard, if not impossible, to overcome in most cases. So, they took the case to the court. The court accepted the case, and at the end of its term, on the last day of its term, actually issued a decision in the case that it kind of accepts the general premise of what West Virginia and those on its side asked the court to do, but doesn't go all the way, somewhat thankfully. So the court kind of accepts the idea that the major questions doctrine exists. It describes it using that name for the first time. And it says that in certain, unusual cases, in certain extraordinary cases, it's going to apply this sort of common sense and also constitutionally based assumption that Congress didn't mean to give agencies, broad authority to do things like reshape a market or, impose a really significant regulation. So I say it did kind of go all the way because it does, have that limiting language in there. The court does say, it's not supposed to apply in every case. But the decision's also pretty mushy in terms of saying when it does apply and the factors that it's going to consider. So it's a little hard to say what the effect of the decision will be because we don't have a lower court decision applying it yet. But, I think it's safe to say that the reason this doctrine was kind of invented and created and taken to the Supreme Court was because it's deregulatory. It was kind of another tool in the toolbox of people who don't like federal regulations. And we know from what has happened, in the run up to the decision and after it, that that's exactly how it's being used. So we know that people have kind of been making noises either in their comments to agencies or in briefs before federal courts or press statements that they think that, a whole host of federal regulations should be challenged on this basis. And that ranges from things like the Department of Transportation's fuel efficiency standards for vehicles, the new rule that the SEC is working on related to climate disclosures, things going all the way down to things that seem pretty major, like the EPA's rules regarding overcoming tampering, preventing tampering of cars to get around emission standards. And then things that have nothing to do with the environment, things like the DACA program. So that's an immigration-related law. There's challenges to visa programs related to the major questions doctrine. Like I said, it's a tool in the toolbox of people that don't like regulations. And those people see everything as a nail and are taking out this hammer and banging on it. And, I don't mean to say, I just want to be clear, like, the fact that people are raising this argument all the time doesn't mean it's a good argument. It doesn't mean it's going to win, but it does mean that the doctrine is serving exactly the purpose it was created to serve.
Right. I'm curious about how all of that fits in with the context of the Inflation Reduction Act too. First, I'd love to sort of hear from both of you your thoughts on gaps in that legislation and where litigation might play a role in addressing some of the concerns that people have about it. But then I also wonder how people are thinking about litigation given what's happening at the Supreme Court right now, kind of broadly.
Sure. Well, why don't I take the first part of that question? The first part, what does the IRA do and what's the role of litigation in the IRA? I'll let Kirti talk a little bit more about the impact of just the general impact of this Supreme Court on litigation in service of environmental and public interests. The IRA is first and foremost a spending bill. So one of the things about it is that it's basically giving money to a whole lot of different sectors, including the clean energy sector and the oil and gas sector, in the form of various tax credits and other direct spending. And that kind of policy work is not the sort of thing that the Supreme Court is going to have a lot to do with, or the federal courts in general, because it's spending. This isn't regulation. And politically speaking, that's actually been the secret to making progress legislatively on climate, is to say, like, let's spend our way out of this problem. Let's invest in a clean energy economy. And the deal, of course, was that this had to go along with a lot of oil and gas and problematic spending as well, including in technologies like carbon capture and sequestration and blue hydrogen, which are at best unproven and at worst really just the same old stuff in disguise. So on the IRA, some of the problematic elements have basically been the parts that are going to make it easier and cheaper to expand fossil fuel infrastructure across a lot of places in the country that already have a lot of that infrastructure, and that, as a result, involve a lot of pollution burdens on the people who live there. And so, ironically, a lot of those communities are the foundation of a movement for climate justice that is very much part of the political support for this legislation and for President Biden's overall success in the last presidential election. So it's ironic that they're going to, in many respects, see the raw side of this deal. So what role does litigation play? Well, nothing in the Inflation Reduction Act, nothing in there limits the role of traditional environmental laws. And that means that all of that infrastructure, oil and gas and problematic pollution generating infrastructure, is going to be subject to those laws. And so litigation is going to have a substantial role in making sure that any development that's supported under this act is going to have to pass through the gauntlet of those laws. And organizations like EarthJustice are very much going to be helping those communities fight back to make sure that the future that they get out of this bill is a future that they want. Anyway, we could go into that a little bit more, but I'll let Kirti talk about the court.
Yeah, I mean, as to the Supreme Court, I'll just, it's not like the Supreme Court has ever been like super environmentally friendly. So
remember the climate court? No, I'm just kidding.
Yeah, exactly. So I think it's important to just like set the baseline in the right place. But that said, obviously this is a different court. This is a more conservative court, a court that's more skeptical of federal authority and of federal agency authority in particular. But that doesn't mean that like everybody should pack it up and go home. It just means that, as with any challenge in litigation, you have to be forward thinking and kind of smart about how you approach litigation and think about where the risk is and think about where you can make progress despite that risk. And as Sam, I think, kind of previewed, there's lots of sort of bread and butter environmental litigation that just isn't going to make its way up to the Supreme Court because it doesn't implicate the kind of big picture issues or principles that the Supreme Court is concerned about. And those are things like, when a facility gets built, it has to, get certain permits, and then those permits need to be enforced. And our federal environmental laws allow citizens, people who live, across the fence line from these really polluting facilities, to help enforce those permitting conditions, right? And so those are the kinds of suits where it's just about a specific permit and whether or not it's being complied with. It's not about some big question of federal power, right? So those are the kinds of things where if you hold people to their legal obligations, you can have an effect in these frontline communities on these facilities that unfortunately and wrongly are disproportionately burdening these people. But that's the kind of litigation that's not going to that doesn't really happen in the shadow of the Supreme Court. And even in bigger cases, we at EarthJustice had a pretty important Clean Water Act case a couple of years ago that our litigators won before the Supreme Court. And it was the 5-4 version, not the 6-3 version, but even so, we still won that case and would have won it under this court. So, and that's just a matter of being, understanding how this court looks at statutes, understanding the perspective of the Supreme Court and speaking in the language they want to be spoken to, right? So that's just litigating well. and you can still win cases that way. So, I don't mean to be like rosy-eyed about everything, but I think there's a certain degree of just like really good lawyering will still win cases, and really strategic lawyering can still make a big difference.
I'm curious what you both think about some of the quote unquote side deal, the aspects of that related to the IRA, especially in terms of, permitting and NEPA and the ways that what at least has been kind of reported on so far seems to be getting around some of our kind of, environmental laws in favor of permitting things like pipeline. And I want to ask you specifically about the Mountain Valley Pipeline in a minute too. But in general, I guess how is EarthJustice approaching that conversation, and what are the things that that you're kind of hoping to not see in the final version of that?
Well, this is Friday, August 12th. It's a big day for passing the overall IRA. So, first and foremost, we're looking forward to passage of the bill, and we're looking forward to President Biden signing it. It's worth noting that, the draft of this side deal that we have, which is kind of freakishly watermarked as API draft, is from several weeks ago. And there's been no indication from Senator Schumer or Senator Manchin's office. We haven't seen a more recent version of this side deal. In fact, the version that we have seen doesn't even include what we gather are some specific deals about the MVP, the Mountain Valley Pipeline. So a lot of what I'll say here is based on something that may not be the current deal. That said, the version that we saw from a few weeks ago includes a couple of major provisions that are problematic on their own. One is a series of provisions that are designed to, in quotes, streamline the permitting process. And what that functionally means is making it making it easier for agencies to do NEPA analyses by making those analyses less thorough, or allowing them to do less thorough analyses. And then by making it harder for people to comment and seek judicial review on those analyses. For example, the statute of limitations for NEPA challenges in most cases is 6 years, and under the draft that we've seen, it would be 5 months in some cases. And that may seem like, well, that 5 months, you should be able to know if there's a problem with a project. But in fact, many of these projects get approved long before anyone in a community has any idea that something is up. And so given the way that we notify communities about what's going on, 5 months is often a laughably short period of time for them to be able to respond in court. There's also a bunch of other provisions that essentially require the president to prioritize large oil and gas development for special attention through the permitting process. And there's also some things that affect the Clean Water Act. There's some things that are generally pro-electricity infrastructure, but also contain some problematic provisions. So there's a lot of stuff in there. We don't really know what the final deal is going to be. But we also know that, unlike the IRA, there's going to be a real legislative conversation about this. We know that the House hasn't passed this. This may be a deal among a couple of senators, but that doesn't mean that the House of Representatives is going to do it. And as we hope, the IRA is going to be passed, and this side deal is going to have to pass independently. I'll let Kirti talk a little bit about what the rumors of what we've heard about this Mountain Valley Pipeline, and the side deal also includes this slightly odd judicial review provision as well.
Yeah, Kirti, can you talk a little bit about the Mountain Valley Pipeline, and also, like, related to that, the way that, at least what we've seen and what's been kind of shared with the press, the way that it would dictate jurisdiction seems really troubling, I think. So yeah, I'd love to hear your take on that.
Yeah, so as Sam kind of previewed, for when it comes to Mountain Valley Pipeline, we don't even have, the draft text of the provision. We have kind of a rumor that Mountain Valley Pipeline and its backers want and have, I guess, secured language that would take cases out of the Fourth Circuit, which is where they're filed under the default, like federal statutes, and I think potentially put them into the DC Circuit. And the reason Mountain Valley Pipeline wants this is because basically the way that courts of appeals work is, most of them have a rule that says, when one panel, which is 3 judges, gets assigned to a case, if a later case comes up that, involves the same project or, set of issues or similar record, it's just more efficient to assign those to the same panel because they're already familiar with it. And so Mountain Valley Pipeline's first case got assigned to a panel in the Fourth Circuit, and most of the later cases related to that pipeline have also been assigned to the same panel. And Mountain Valley Pipeline is upset that it has lost some of these cases and already complained to the Fourth Circuit itself. So, in some of the decisions that it's lost, and I should be clear, it hasn't lost all of these decisions. When Mountain Valley Pipeline is making this claim, it excludes from the baseline of the number of decisions that it's talking about a bunch of decisions related to condemnation, which is its authority to take land for the pipeline, almost all of which the same group of judges has upheld. So allowing them to take private property under federal statutes to build their pipeline. So it kicks those out of the denominator to make the numbers look less favorable to it. And then it says, we're losing more of these cases than we think we should under the law of averages, I guess. And it's already complained to the Fourth Circuit in its petitions. When it loses a case, it's petitioned for rehearing en banc, which just means it's asked the full Fourth Circuit to consider these decisions, and it's kind of jabbed at the panel in those filings. And the Fourth Circuit hasn't, full Fourth Circuit, so including other judges, right, hasn't taken the bait, hasn't thought that there was, worthwhile merit to those claims. And it actually moved to basically disqualify the panel recently and asked the Fourth Circuit to assign these cases to a different panel. And the Fourth Circuit said no. And, just to be clear, it's not losing all these cases at all. If you read these decisions, the panel will accept some of the claims, it will reject some of the claims. They're thoroughly reasoned decisions. It's not they're knee-jerk anti-pipeline decisions. They're just holding the federal agencies, which, have obligations under federal statutes, to their burdens. And so I guess having, failed to make an argument that would win in court, Mountain Valley Pipeline has now gotten its backers to take these cases away from the Fourth Circuit and put them in the DC Circuit. And I have to say, reading these decisions, I didn't work on these cases, so all I've done is read some of the opinions, but they don't strike me as the kind of opinions that would come out differently if you put them in front of a different set of judges. And not to psychoanalyze judges, but I can't imagine the DC Circuit is going to be, that pleased that, this pipeline company thinks that they looked around the country and wanted to pick their judges and decided on the DC Circuit. I don't think federal judges in general like the idea of judge shopping in that way, or implying that, the Fourth Circuit is biased. Those are their colleagues too. So I'm not really sure it's going to work out any better for them at the end. But, just Amy, your question kind of hinted at it, that it just is a bottom line matter. It's sort of distressing that a really powerful industry group can pick its judges in its cases in order to kind of gerrymander the outcomes that it wants. That just on its face looks really bad.
Seems like a bad precedent to set.
But at the same time, it's ironic that they want to be in the DC Circuit because,
right.
The DC Circuit is not the Fifth Circuit. In fact, as environmental lawyers, that's not a bad place for us. It tends to be a highly technocratic and very, back when I was an active litigator, that was my favorite court to litigate in because they dug in and they would really get to know the details of the arguments. And if I'm not at all sure that if I were an industry, that's where I'd go. Now, certainly, if they had said we want to go to the Fifth Circuit, I would have, number one, said, well, I can understand why. And number two, I would have been all the more distressed that they really were just forum shopping in the most naked way. So anyway, I share Kirti's concern that we're moving specific cases around. I do think it's sort of funny that they may be out of the frying pan and into the fire.
Yeah.
It'll depend on the panel draw they get in the DC Circuit.
Yeah. I know. I thought that was weird too. It was like, it's not like that's a slam dunk for them. Okay. So looking ahead at the next session of the Supreme Court, obviously West Virginia versus EPA is not the only, environment or climate related case that they have taken up. What should we be looking out for? What's coming up next? I know, Sam, you kind of wrote about this recently.
Yeah, well, the blockbuster case of next term, or at least so far, the likely blockbuster is the Sackett case, which involves the Clean Water Act. And the Sacketts have been serial litigators on this issue and have been to the Supreme Court before, where they won 9-0 on a fairly straightforward question about whether or not they had a right to be in court at all on this. They're a couple whose claim is based on their desire to get a permit to do some development, and their belief that they shouldn't even have to get a permit. To be clear, if they had applied, they almost certainly would have gotten a permit, but they don't even feel like they should have to get one. And the permit is to fill in some wetlands on their property. And the real underlying question is, what does the Clean Water Act protect? And everybody understands that the Clean Water Act protects lakes and rivers and the ocean, big rivers in the ocean. But the fight for some time from the right has been to constrict the applicability of the Clean Water Act to smaller streams and to wetlands. And of course, any scientist would tell you that there's no way to protect the water quality in downstream rivers and lakes in those bodies that nobody contends aren't protected by the Clean Water Act. But if you want to protect those water bodies, you need to protect the upper parts of the watershed, which often involve smaller rivers and streams, and then the wetlands that feed them. So there's a lot of industries that would like to be able to fill in wetlands and frankly pollute areas that currently the Clean Water Act protects. And by arguing that the Clean Water Act doesn't protect those things, they're essentially going to accomplish deregulation. So they're not changing the protections of the Clean Water Act. They're changing where they apply. Now, the court has been very interested in this issue for a while. And back when Justice Scalia was around, he wrote an important opinion that only attracted 3 other votes. So it was only an opinion of 4 justices and therefore wasn't controlling. But it suggested a much more constricted understanding of what the Clean Water Act protects. And we know that I think everybody is predicting that this court will try to put Justice Scalia's test in charge, which would again be a much more restricted understanding of what the Clean Water Act protects. That's the blockbuster. But there are some other maybe less appreciated cases that will have a lot to do with environmental law. I mean, it's not always environmental law cases that affect what environmental law does, because administrative law, the law of regulations, is props up in lots of contexts, not just the environment.
Right. Well, I have one follow-up on the Sackett case. Do you have any sense of kind of where that case came from in terms of, I'm curious if it's like, is it a Raga case? Is it like, how coordinated is the?
Well, I mean, it's, let's put it this way. If it is awfully convenient for the many organizations that are supporting the Sacketts, that the Sacketts themselves are a sort of libertarian face of this with just this this couple that seems like just a mom and pop trying to get something done. But it should come as no surprise that organizations like the American Petroleum Institute are happy to file major amicus briefs, and the Sacketts are being represented by folks who are movement and agenda lawyers. So this may not have been, I'm not sure anybody called them up and said, hey, you should try to build something and then we'll make a case out of it. But certainly when their case popped up, it attracted a lot of attention and a lot of support because it was a vehicle that a lot of not mom and pop operations were interested in seeing succeed.
Right. Who's representing them?
It's the Pacific Legal Foundation.
Oh, okay.
Yeah, I mean, this is not look, we're an organization with a point of view, and I'm sure that there's people at the Pacific Legal Foundation who would say, oh, well, EarthJustice is representing them. The difference is we don't have a whole lot of industries who are also feeding us money in order to do that. We are not on the side of industry, and we don't have the American Petroleum Institute filing next to us.
Right.
Yeah. And I'll just, just to inject a bit of, I think Sam's laid out just how important the Clean Water Act is and how important a decision that restricts its scope and what it is capable of protecting is to, like real people on the ground, many of whom are our clients. But it's probably also worth just noting that these briefs that Sam mentioned, from people like the API, the Chamber of Commerce, Americans for Prosperity, a group of red states, again, led by West Virginia, these briefs aren't, there's something similar to what was happening in West Virginia versus EPA going on in these cases. They're not just about the Clean Water Act. They're also kind of trying to seed these anti-regulatory principles in the same way as they succeeded in West Virginia. They're asking, they're telling the court things like, the Clean Water Act is, addresses public health and safety, and that's traditionally an area of the state's control, not the federal government's control. So it's got to be really clear when there's a federal statute that invades that traditional state authority. All these kind of clear statement rules is what they're called in the law that basically act as thumbs on the scale against federal power or agency power. This is round two of trying to develop additional tools that can be used in later cases and later challenges. So it's not just, it's about the Clean Water Act. All these groups have a very obvious interest in avoiding the application of the Clean Water Act, right? But it's also that they see this as another opportunity before this court to kind of establish broader legal principles that they can then use going forward.
One thing you notice is Kirti and I both worked at the Supreme Court at very different times. And when I was there, the swing vote was Justice O'Connor, who I worked for, or in some cases, Justice Kennedy. And back then, people didn't push these big legal principles. They didn't really, in some cases, they would talk about deregulatory ideas or returning power to the states to appeal to Justice Kennedy. But in general, people were kind of swinging for singles. They were trying to win small and individual cases and build big. And what you're seeing in cases like Sackett is, I think the other side on these things is assuming that they're going to win the narrow case. They're pretty sure they're going to win the Sackett's case, and they're swinging for the fences to get broader principles. So in the West Virginia versus EPA case, all of us on the outside were saying, why would they have taken this case about a regulation that doesn't even exist if they were going to say that the regulation was fine? So we strongly suspect that they're going to try to strike this regulation down. So the fight is really about how far do they hit that ball into the outfield and do they get a home run? So what you see in the briefs on the right is just egging the court's conservatives on to say as much as possible through the vehicle of the case.
Yeah. Okay. And then you mentioned some other cases that could have a big impact on environmental issues in general, but are not necessarily explicitly environmental cases. Could you expand on that? Which cases are you kind of keeping an eye on in that regard?
Yeah, there's one case called Ross, and it's actually a constitutional case. It's not an administrative law case, and it's about the what's called the Dormant Commerce Clause, which is like law speak for like an unwritten principle that is derived from the Commerce Clause of the federal Constitution. But basically, this is a case about a ballot initiative that was passed in California. It's called Proposition 12, and it's a law that prohibits people from selling pork in California that is derived from an animal that was confined in a cruel manner, which is, defined as things like, preventing the animal from being able to lie down or turn around or being in a space that's too small. And pork producers have challenged this law as violating what's known as the Dormant Commerce Clause. And the basic idea is that the federal constitution gives Congress the authority to regulate interstate commerce, so commerce between states. And so the kind of principle that the Dormant Commerce Clause enforces is the idea that if that's Congress's power, then states can't do that. And so when states try and do that, that violates the so-called Dormant Commerce Clause. And there's different ways that the Supreme Court's cases describe how this principle could be violated. One is when a state sort of literally writes a law that says if it's Texas and they write a law that says Louisiana products can't be sold here or something like that, right? So one is where it's obviously discriminating against interstate commerce. Another one is this kind of mushier balancing test where if a state passes a law that burdens interstate commerce, that the court's going to kind of balance whether or not that benefits that the state is offering in support of that law outweigh the burdens on interstate commerce. And the last one, which is kind of the most important for the discussion we're having, is this principle called the extraterritoriality principle, which is the idea that even if a law is written to address in-state activity, if it has effects outside of the state, that can raise concerns that would require the application of a constitutional test. And, obviously this case is important on its own facts, but the reason it's important in a broader sense is that folks have challenged laws like renewable portfolio standards under this extraterritoriality principle. The idea being if a state says, X percentage of our energy has to come from renewable sources, we live on an interconnected grid, and so that has some effect on the production of energy outside of the state. And in a sort of weird moment of potential hope, a lot of conservative judges, I should say, not all of them, but are kind of unhappy with this extraterritoriality idea because, the whole Dormant Commerce Clause enterprise is not really based in the text of the Constitution, and this extraterritoriality principle is kind of the most formless of all of them, right? It's if there are some effects, then you question its constitutionality, and almost everything has effects. Almost everything in our modern world has effects outside of the state. And so Justice Gorsuch actually wrote an opinion when he was on the 10th Circuit upholding Colorado's renewable portfolio standards under a challenge based on this extraterritoriality principle. And so, I think there's a chance that in this case, the court maybe goes towards limiting that and then keeping those kinds of RPS laws on safer grounds, not, in the text of the opinion, but sort of as a consequence of the opinion. So that's one to watch as well. And then there are just kind of other cases that, you might not think of as environmental cases, but the court's hearing a big affirmative action case next term, and it'll be important to see what the court says about that for things like environmental justice laws or projects or programs, and which try to protect overburdened communities, and often there is a corollary with race. And so understanding what the court thinks about when you can address those situations is going to be really important. There's an administrative law case the court just took where it seems like the court's going to address a pretty important issue about when states have standing to sue and potentially make it harder for states to have standing. And so in a world where the courts, making it harder for individual plaintiffs to sue, one sort of bright spot has been that, at least for the environmental community, is that, blue state coalitions can still bring suits. Obviously, there's a trade-off with the other group of states being able to bring suits as well, right? But that's been one way to get into court. And so that's another decision we'll be watching to see what the court says about state standing. And that's only, the court's only taken like maybe 2 sittings worth of cases. So there'll be more to come.
Yeah. Yeah. Is there any sense, I mean, like I've, especially with oil companies, I don't know, like I wonder if we'll see U.S. oil companies being sued in other countries more, even if they start to get away with things here.
Well, it's certainly the case that we, EarthJustice does have an international program, and our international program primarily supports public interest law organizations in other countries. The U.S. has a very developed public interest environmental law program, and that's not to say it's very, very, it's enormous. We have about 180 lawyers, and that makes us huge and a giant law firm in the public interest world, but that's still pretty small in the grand scheme of things. In other countries, it's an order of magnitude, if not less than that, in terms of what the resources are there. Having said that, those organizations and regular old people in other countries have been very successful in pushing back on international and U.S. oil companies for the local harms that have been happening where they have the resources to bring those cases. Again, the public interest legal community in countries like South Africa or Australia or Latin America, in general, they're just much less well resourced than we are in the U.S. and the structures for public interest law are much less developed. But the flip side is some of those countries have provisions in their constitution that are more directly relevant to those claims. And so we're seeing, for example, in places like South Africa, where plaintiffs have been able to say, hey, look, we have legal protections on these things, and you, the courts, need to figure out ways to bring those protections to life.
I mean, our federal constitution doesn't have, those kinds of express provisions, but some of the state constitutions do. I don't know. I wanted to talk about that a little bit.
Sure. I mean, there are direct state constitutional protections, like Montana. I don't know the precise language off the top of my head, but Montana's constitution does have protections for people to make sure that they have a clean and healthy environment. I forget what the exact language is, but what that means is that there's an ability for people in Montana to go to court to say, hey, this thing that's happening violates the state constitution. And then there are also states like Louisiana and Hawaii that have public trust doctrines. And those are doctrines that say that the state government, that state land that there's an obligation of the government to be protecting that in the public interest. And in some of those states, we've been able to make some headway, and other public interest litigants have been able to make some headway in saying, hey, your state courts need to do something with these things. These can't just be written on paper. And then finally, there are states like New York that are enacting transformative legislation, like the CLCPA, the Climate Leadership and Community Protection Act in New York. And those are super important tools. And I think those are increasingly going to be the focus of political climate and state level climate action, because those laws are going to be really important. And we're going to see those being done both statutorily by legislators, and I think also through ballot initiatives that we've seen in places like Washington State and elsewhere to bring real legal protections at the state level into play.
That actually totally dovetails with my last question, which is, we kind of touched on this earlier too. I think that there's a certain amount of understandable pessimism about, litigation, because ultimately it will end up in the Supreme Court, and then the Supreme Court will rule against anything that's good for climate. That's like the, in very broad strokes, the sentiment that I hear a lot. So I'm curious what your response is to that.
Oh, I think the courts are going to remain super relevant, and if anything, more relevant. The old model of environmental law was to fight at a purely regulatory level, to sort of go to court and say, here's the Clean Air Act. We're going to sue EPA for not issuing stricter regulations on this. Or if the regulations come out and the industry challenges them to be in there to say, hey, wait, these regulations are fine. And I do agree that with a highly deregulatory and skeptical of agencies Supreme Court, that kind of litigation is going to be harder, and that we're going to have to be more thoughtful and cautious in the cases that we bring, and more aggressive in our defense of regulations that are on the books and statutes that are on the books. On the other hand, the climate justice and environmental justice movements are deeply dovetailed with the need for getting systematic change in the way we regulate pollution and climate. And a lot of those cases are very much local, fact-intensive, and specific cases about specific harms and specific violations of law that are part and parcel of a movement for broader change. And those kinds of cases brought on behalf of communities where you're going into court saying, this isn't about some abstract principle that's way over there in Washington, D.C. This is about real people and a pipeline or a mine, or pollution that's affecting real lives, whether it's, lead in the water or smog in the air. Those cases are going to be really important in the years to come. And those are cases where what matters is the facts you bring, the partners you bring, the industries that you're dealing with. I think those cases are very live, and I don't see any way in which those cases are going to be like fundamentally harder to bring. There's things like standing and others that the right-wing courts are trying to, these little doctrines that the court is trying to chip away on the side. But I fundamentally believe that those cases are going to be both increasingly important and that they're going to continue to be very viable and very, very powerful.
Drilled and Damages are original Critical Frequency productions. This episode was reported by me, Amy Westervelt, and mixed and mastered by Bennett Smith. Original music is by Peter Duff. Our artwork is done by Matthew Fleming. For ongoing information about climate litigation and all sorts of other things, check out our website at drilledpodcast.com. You can also follow us at We Are Drilled. That's it for this time. Thanks for listening, and we'll see you next week.